Today's lecture, we continue our journey in contracts on Chapter 15, Illegality. The general rule is that some contracts are illegal and then thus are unenforceable, not void, not voidable, but unenforceable. Thus, an otherwise valid contract will be deemed unenforceable if its performance is illegal, criminal, tortious, or violates a statute, or is contrary to public policy. The idea behind this is that the public welfare is more important than the right of people to bargain freely. Courts want a legal result, and thus when faced with something that appears to be illegal, all doubts will be resolved in favor of legality, and thus if there's usually a tint of illegality, the courts won't address this and will deem the contract illegal and thus unenforceable. So again, the courts will take a hands-off position to illegal contracts and won't enforce them. Parties thus are left as the courts found them. Courts don't want to get involved to protect the public. And in addition, could you imagine how flooded our court system would be with illegal or unenforceable contracts? The wheels of justice would never get done. However, there are some situations where you may have at least part of an illegal contract. You see 4 of them here on the slide. The first one is ignorance of fact. Under ignorance of fact, sometimes courts will allow for recovery if either one or both of the parties are ignorant of the facts that made the bargain illegal. Recovery is allowed only for the portion rendered before learning of the illegality, and if the illegality does not involve such things as immoral behavior or illegal behavior does not present a serious threat to the public's welfare. So, for instance, let's say Frank wants to rent out Mary's playhouse to conduct a play. However, Mary does not have a permit to operate the facility. Frank has paid his employees in anticipation of the play. Although it's illegal to operate a playhouse here, Frank can sue Mary for lost wages that he had to pay to his employees. The second special circumstance is rights of protected parties. And thus, statutes protect certain classes of the public. So for instance, citizens of a state that licenses corporations are generally allowed to enforce their contracts with an unlicensed foreign corporation. Thus, a corporation doing business in another state and is unlicensed to do so can't get away with saying the contract was illegal and thus unenforceable. The third special situation is a rescission before the illegal act is performed. Courts allow a party who rescinds or cancels the contract before any illegal act has been performed to recover any consideration that is given. Let me use an example out of the book. Let's say John is the owner of a restaurant, and John offers Bob, who happens to be an employee of a competitor's restaurant, $1,000 for some of John's competitor's secret recipes. So John gives Bob $500 in advance. If John is having second thoughts or having doubts and tells Bob before receiving any secret recipes, John can get his $500 back. Finally, the fourth special situation deals with illegality in divisible contracts. So if a contract calls for performance of several promises, some of those promises are legal and some of those promises are illegal, the contract can be what's called divisible, which means courts will enforce the legal parts of the contract, but will throw out as unenforceable the illegal parts of the contract. Now let's look more specifically at certain types of contracts that are unenforceable because they are illegal. Well, the first types of contracts that are illegal seem rather obvious. 1, agreements to commit crimes. And 2, agreements to commit torts. Let's start with crimes. So a contract that requires committing a crime is illegal. So thus, if I contract with a student to go kill a professor I don't like, the student, and I don't pay that student, the student can't go to the courts and say, hey, enforce this contract, because the courts are going to say the contract was to commit a crime, thus it's illegal and thus unenforceable. Same thing with an agreement to commit a tort. So if my son on the playground contracts with the bully to have the bully punch one of his enemies, same thing. Any contract to commit a crime or a tort is illegal, and if it's illegal, it's thus unenforceable. Other contracts that are illegal and thus unenforceable have to do with such things as wagering, usury, or Sunday laws. Let's start with illegal wagering. Illegal wagering is when the parties to a contract create a new risk for the sole purpose of bearing it. Most states prohibit or regulate gambling, although some states are starting to make what was once an illegal thing to do, wagering, now legal. You're seeing this in such states, not only as Nevada for many years, but in such states as New Jersey. However, most states still consider wagering illegal. So could you imagine if you bet on the Super Bowl and you lost just with a friend in California? You can't, you decide not to pay, the friend can't go sue you in California court. The court would say it's an illegal wagering statute and thus is unenforceable. Please keep in mind when talking about wagering statutes, the difference between a traditional wagering statute that is unenforceable because it's illegal and a risk-shifting statute or a speculative bargaining agreement which is legal. A risk-shifting agreement is something that shifts the risk. So like for instance, when you get insurance for your car or your house, that's a risk-shifting agreement and thus is legal. Speculative bargaining agreements are also legal. This deals with such things as purchasing stocks or derivatives. You're speculating on whether the underlying stock or derivative is going up or down. I also want to talk a little bit about usury laws. Usury laws are laws that prohibit charging more than a set amount of interest. Finally, I want to talk about Sunday laws, or what's commonly known as blue laws. And blue laws prohibit certain work on business on transactions from being performed on Sundays. You don't see that a lot here in California, but oftentimes you'll see it in more conservative areas of the country, such as the Bible Belt. People who violate regulatory statutes Also, it will be illegal. A regulatory license is needed for certain professions. So thus, people who engage in certain work without a license, any work they do is unenforceable, and thus they can't collect for any work rendered. And these licenses are here to protect the public welfare. A statute that provides either, some sort of skill set and impose a penalty for violations. So for instance, you just can't practice accounting unless you have a CPA. You can't practice law unless you have passed the bar. You can't practice medicine unless you are licensed to do so. So people who try to practice medicine, for example, without passing the med exams, they can't collect for their services. Please note the difference between a regulatory license, which will be illegal if you violate that because you're not qualified, and a revenue license. If you violate a revenue license, your contract is still legal. Under a revenue license, failure to obtain a license required by the statute, whose sole purpose is to raise revenue, does not affect the legality of an unlicensed agreement. So for instance, oftentimes you go get a fishing license. Anyone can go get a fishing license. There's no skill or test needed to do that. So if I were to take a group of people out on a fishing trip, if I wasn't licensed to do so, then the people who paid for the fishing trip can't sue me based on the fact that I didn't have a license here. I can still collect for the fees that I charged them because I didn't violate a regulatory license. I violated simply a revenue license. Now let's look at contracts that are not necessarily violating a statute, but instead are contrary to public policy. As you can see, what's the definition of public policy? It's what is in society's best interest, not just an individual, but society's best interest. And I think an important thing to know is that public policy may change with the times. So let's look at some of these here. The first one has to do with contracts that are injurious to public service. So agreements that induce public servants to deviate from their duties are illegal. So you can't pay a cop more to watch your property over society, the public at large. I'm going to skip number 2, contracts to influence fiduciaries, and let's move on to the third and fourth one. Number 3 deals with exculpatory clauses. Exculpatory clauses are provisions in a contract that attempt to relieve one party to the contract from liability for the consequences of his or her negligence. Public policy generally favors holding people responsible for their own behavior. So thus, oftentimes, a parking lot operator who attempts to relieve his or her liability by issuing for their own negligence while the car is parked through language on the parking lot ticket won't be able to enforce that via public policy. Finally, number 4 is a restraint on trade. I want to spend some time on this. A restraint on trade is an agreement that attempts to limit competition. Since we live in a capitalistic economic system, we like competition because competition generally increases the quality while decreasing the price. However, a restraint on trade that is ancillary to a contract may be deemed legal if such restraint is designed to protect the interests created by the contract, and in addition, the restraint is no broader than necessary to protect their interests. We're going to look at this from 2 perspectives that are not on the slide. The first is a sale of a business, and the second is an employment contract. First, a sale of a business. So, for instance, let's say I want to buy Rigatoni's Pizza here in Quartz Hill, and I finally get the owner to sell it to me. In the sales agreement, I say that you, the owner, the former owner of Rigatoni's Pizza, can never open up another pizza place in California for the next 40 years. The general rule about a sale of a business is this: the restraint will be allowed if it's reasonable as both to time and geographic location. Well, the restraint of trade that I put on with the sale of business with regards to Rigatoni's will not be allowed and will thus be unenforceable because it was both unreasonable both for time and geographic location. I said that the former owner couldn't open up another Rigatoni's or another pizza place for, I believe, 40 years, and couldn't even open up one in all of California. That's too long of a time and too broad of a geographic location. The second area I want to look at under restraint of trade is employment contracts. And sometimes employment contracts have language in it that says, if you leave, you can't go work for your competition. Oftentimes, these are known as covenants not to compete. And covenants not to compete may be upheld as legal and thus not a restraint of trade if the former employer is trying to prevent trade secrets or trying to prevent the employee who left to go work for the competition from taking the employer's customers. And they're okay with regards to time and geography again. However, there's a much stricter standard that we use for employment contracts and sale of a business, because with a sale of a business here, we're trying to protect someone here who has made money by selling a successful business. With an employment contract, here what we're trying to protect is a worker who may not be able to leave one company for a new company and may not be able to get a job and thus provide for their family. And so thus the restraint on trade with regards to employment contracts will be much stricter enforced in terms of being viewed as illegal for an employment contract than it will be for a sale of a business. Finally, I want to look at what's considered unequal bargains. Now, if you remember from a previous chapter, when we talked about adequacy, the law doesn't care who got the best deal. Sometimes in contracts, one party gets a better deal and another party gets the short end of the stick. However, there are a couple situations I want to address where we have such unequal bargains that the courts will not enforce the agreement because it looks so bad, it'll thus be considered unenforceable. The first one I want to look at is an adhesion contract. An adhesion contract is where the only choice for one party is to take the deal and thus adhere to the other person's terms or to walk away. So oftentimes when you go somewhere, you have it as a take it or leave it basis. Sometimes the courts will view that as a contract of adhesion because sometimes there will be boilerplate language or really bad legal jargon that people don't understand. And if you don't use it on their terms, you have to take it away. That sometimes can be construed as a adhesion contract and thus is unequal bargain and thus is unenforceable. The last one I want to look at, or the second one I want to look at, is what's called an unconscionable contract. Now remember, I said the law doesn't care about adequacy, but sometimes the courts will look at a contract and deem that that contract is so unfair that it quote unquote shocks the conscience of the court. So for instance, paying $8,000 for a Kirby vacuum cleaner might be such a one-sided contract that it's deemed to be unconscionable and thus it's not enforceable. That wraps up today's discussion on Chapter 15, Illegality.